Good morning. Yes. For the list.
Supplementary causes under the heading to be mentioned, serial number 1, serial number 2, penal division 1045 of 40, with penal division 1052 of 40. These are against my causes cases.
Lord, I am appealing for the petitioner.
There's a typographical error in first, second, third. In third paragraph.
Lord.
There's a typographical error in the order sheet dated 8/2/2022, full stop. The case number in the cause title has been wrongly mentioned. The criminal revision number of Ramesh Kirwal has been wrongly mentioned as criminal revision number 1045 of 14 in place of 1052 of 14. Full stop. In third paragraph, the criminal revision number 1045 of 2014 has been wrongly mentioned as 1045 of 2016. In first, second, third, in third paragraph of page number 1 and also in sixth paragraph of the order at page number 2. 1045 of 2016 has been mentioned as 1045 of 2014. Full stop. Next para. So the said typographical error is hereby corrected. In the cause title, the criminal revision number of Ramesh Kirwal be read as 1052 of 2014, and in paragraph 3 and paragraph 6. In paragraph 6, the case of criminal revision be number 1045 of 2016 be read as 1045 of 2014.
Right.
Yes, next.
Next.
From daily causes under the heading order to defect, serial number 1, MA number 386 of 19. Mr. Arvind Prajapati, Mr. Jagdish for the appellant.
Your Lordship, in this case, I am appearing on behalf of appellant. I am humbly seeking 2 weeks' time to remove the defect. Your Lordship.
2 weeks time to remove the defect.
Oblige, Your Lordship.
Serial number 2, MA number 513 of 19. Mr. Arvind Kumar Lal.
I request my lord to grant 3 weeks time, my lord, to remove.
3 weeks time to remove the defect.
Serial number 3 with serial number 4, MA number 534 of 19 with MA number 542 of 19. Mr. Arvind Kumar Lal.
Give there, my lord, 3 weeks,
3 weeks.
my lord.
Serial number 5, MA number 601 of 19. Mr. Virendra Kumar for the appellant.
I also pray for 3 weeks time, Lord, to remove the defects.
Serial number 6 with serial number 7, MA number 602 of 19 with MA number 607 of 19. Mr. Nikhil Ranjan.
Your Lordship, in these two matters, defects have been removed, my lord.
Certified copy of the order along with authentication fee.
My lord, for that, my lord, I have filed an IA also, and stating that it can be ignored, my lord. Generally, my lord, it's ignored by the Registrar General, my lord. But
Why authentication fee has to be ignored? How does the Registrar General has the power to ignore the court fees?
yes, my lord. My lord, may kindly peruse the IA, my lord. Once. If
And
that
as in the same judgment, there are several cases.
yes, my lord, same accident, same judgment also. In the same judgment, both the cases are dealt. Rule 201, my lord. Page number 3 of the IA.
Page number
3 of the IA. I have para number 4, page number 3.
Para number 4, page number 3. High Court rules, High Court rules.
201, my lord, rule 201.
Yes. 201. What is the point involved in this case?
My lord, on the point that it's a railway accident, my lord. So the court below dismissed the case, and both the appeals have been filed against that common judgment. These people were traveling in a tempo and in an unmanned railway crossing, and the train came and dashed the tempo. The matter went before MSCT, as it is a subject matter of both the jurisdiction of MSCT as well as the railway. Judgment of Honorable Apex Court in this, my lord, and the court below dismissed the case, stating that not maintainable.
Not maintainable.
Dismissed the case, stating opposite party claim not maintainable. Para number 9 of the judgment, page number 9 of running page number 18, internal page number 9 of the judgment, para number 9.
Take down IA number 236 of 2020. Full stop. This IA has been filed to ignore the defect as pointed out by the office. Which office? Full stop. The office has pointed out that the certified copy of the impugned award along with authentication fee should be filed. Full stop. Next one. Counsel for the appellant submits that arising out of the same judgment, and another appeal being miscellaneous appeal number AMA 607 of 2019 has already been filed, in which the certified copy of the judgment has been filed. Instituted in which the judgment has been filed. He submits that in view of Rule 201 of the Jharkhand High Court, the High Court of Jharkhand Rules 2001, the defects may kindly be ignored. First, after hearing the counsel for the petitioner and after producing the provision of section 201 of the Jharkhand High Court rules, I find that arising out of the same judgment, another miscellaneous appeal has been filed. Full stop. The issues involved are same. Full stop. Thus, this defect, so far as it relates to production of certified copy and filing the authentication fee, is hereby ignored. Ignored. Full stop. We raise this case under the appropriate heading of next week.
Obliged.
I dispose of.
Obliged.
Serial number 8, MA number 603 of 19, Mr. DC Jha.
Lordship, 3 weeks time be given to remove defect.
3 weeks to remove the defect.
Serial number 9, MA number 608 of 19, Mr. Manish Kumar, Mr. Amit Mishra for the appellant.
My lords, I pray for 3 weeks time, my lords.
3 weeks.
Serial number 10, MA number 609 of 19, Mr. Manish Kumar, Mr. Amit Mishra.
My lords, I pray for 3 weeks time, my lords.
3 weeks.
Serial number 11, MA number 615 of 19, Mr. Prashant Kumar Ramu.
Madam, 3 weeks for removing the defect, my lord.
2 weeks.
Serial number 12, MA number 618 of 19, Mr. Himanshu S. Pandey, Mr. Virendra Kumar, Mr. Prakash Chandra.
3 weeks time, madam.
3 weeks.
Serial number 13, MA number 643 of 19, Ms. Amrita Banerjee.
No one appears adjourned.
Serial number 14, MA number 644 of 19, Mr. Manoj Kumar number 2.
Only 3 weeks time, madam.
3
For remove the
weeks.
defect.
3 weeks. As per for.
Serial number 15, MA number 650 of 19, Mr. Ramesh Kumar Jha, Mr. Ashok Kumar Singh for the appellant.
In this case, defect number 1, 3, and 4 has been removed. The remaining defect is defect number 2. In that, that defect is regarding correction in the judgment, my lord.
Correction in the
Judgment. Because there is a name, parentage name, address, POPS, district, and other details are missing.
defect number 3 you have removed.
Defect number 1, 3, and 4 I have removed, my lord. Defect number 1 is regarding limitation petition that has been filed. Defect number 3 is enrollment number is missing that has been inserted. And defect number 4 is authentication fee of rupees 15 that has been filed.
There is a subsequent stamp reporting. You see the subsequent stamp reporting. 4 weeks time. 4 weeks time.
Under the heading for orders, and serial number 60, MA number 181 of 15, Mr. DC Jha for the appellant. Mr. Prashant Kumar Srivastava, Mr. Vishal Kumar Singh, Mr. Pratish Kumar, Mr. Vinod Singh for the appellant.
Yes.
Yes, Lordship. Last occasion, the direction was to issue notices on respondent 3, Your Lordship, by registered post and ordinary. I have complied with that order, Your Lordship. I don't know whether respondent 3 appeared or not. Order dated 15/3/21.
Fresh notice upon respondent number 3. Both process requisites 3 weeks.
Lordship, if a return copy be allowed to be used.
It's not there.
Serial number 17, ML number 256 of 15, Mr. DC Jha.
Which is order dated 6/7/21, your lord, may kindly be seen, your lordship.
Who is respondent number 10?
Lordship, His Honor, my lord.
Who is respondent number 10?
He is the owner of the vehicle, your lordship.
Honor, my lord.
Right to recover is there.
Yes, my
Owner
lord.
of the,
Yes.
I am for Clement, my lord. Clement of respondent number 1 to 19. In this.
owner of the vehicle, your lordship, and driving license is in serious dispute. We have examined 2 witnesses and 2 exhibits has been filed with regard to the driving license, your lordship. And our prayer is that even if the driving license is fake, your lordship, it was a fake driving license. It was not issued by the earlier BTO office. So right to recovery should have been given to the insurance company as per the present law. So in that case,
Fresh notice to respondent number 10. Both process requisites 3 weeks.
Lordship, I am for Clement, respondent number 1 to 9, my lord.
Yes.
हाँ ठीक है 10 के लिए हो रहा है
10 के लिए ऑलरेडी लॉर्डशिप कोर्ट बिलो एक्स पार्टी हो गया था वहां पर भी पेपर पब्लिशिंग के बाद भी वो नहीं आए थे.
So,
यहाँ
So,
पे होगा
how can you presume that he will not appear?
Yes, Lord.
Making all sorts of submissions. How can you presume that he will not appear? He may appear here.
Yes, Lordship. I am only informed, Lord Court.
I've seen that.
Yes. Oblige, Lordship.
Yes, next.
Serial number 18, ML number 265 of 50, Mr. Vijay Kumar Sharma for the appellant.
May I please, Lordship?
Yes, Mr. Sharma.
That memo of appeal has been filed for the enhancement, Your Lordship, and the delay of the 71 days, Your Lordship.
Who is respondent number 1?
Respondent number 1 is the owner, Your Lordship, and the respondent number 3 is also owner, Your Lordship.
3 is?
1 and 3 is the owner, Your Lordship.
1 and 3 are the owner. There are 2 owners of the vehicle.
2 is the insurance.
New India and United India, both 50-50.
Contribute negligence.
Composite, not contributing.
No, who is 1? Any relief against 1?
No, Your Lordship. Vehicle was insured, Your Lordship. And liability on the respondent number 2 and 4, Your Lordship.
This IA has been filed to condone the delay of 72 days in filing this appeal. Next paragraph. Counsel for the appellant submits that's that after receipt of the information that the claim case has been decided, certified copy was applied for, which was received on 14/1/2015. Thereafter, as the claimant was suffering from fever and there were some financial issues, she couldn't file the appeal within time. Further, this said that she came to Ranchi during the Holi But since the original file was not there, she returned and again came with all the documents in the month of June 2015 and thereafter filed this appeal. It is submitted that this led to a delay of 72 days in filing this appeal, which is beyond the control. Full stop. The counsel appealing for the insurance company opposes the prayer. Full stop. After hearing the counsel for the parties, I find that sufficient ground has been shown. Delay condoned.
Serial number 19, MA number 269 or 15, Mr. Alok Lal for the appellant.
My lord, in this case, I could not file the petition for substitution of deceased respondent number 7, your lordship. And the notice were filed on respondent number 8. I am not aware of the status, my lord, of the notice on R, respondent number 8. But so far for 7, I have to file a petition for substitution, my lord.
Fresh steps on respondent number 8, ordinary process. Full stop.
My lord, if the written copy is available, can I utilize it?
No, there is no return copy. Then next para. So far as the other defect pointed out, counsel for the appellant prays for 3 weeks time.
No, it is not the defect, your lordship. It is after the your lordship's order, my lord. There is no defect.
So far as the office, so far as the other deficiency pointed out in this office note, the 3 weeks time is allowed to the appellants.
20, MA number 277 or 15, Mr. Ashutosh Anand for the appellant.
Yes.
Serial number 20 is wrongly listed. Serial number 21, MA number 288 or 50, Mr. Vijay Kumar Sharma for the appellant.
May it, your lordship. Instant memo of appeal has been filed by the claimant, your lordship, for enhancement of the compensation amount, your lordship. And the case of the claimant, your lordship, was the injury case, your lordship. And there,
Who is
thereafter during pendency, your lordship, the claimant was died, your lordship.
Who is
And,
respondent number 4?
I am for respondent number 2, your lordship. On
3
behalf
and
of
4? 3 and 4.
KKC.
Who are 3 and 4? Respondent number 3 and 4. Who are respondent number 3 and 4?
Respondent number 4, your lordship.
Wife of the deceased.
Respondent number 4 is the wife of the deceased, your lordship.
Okay.
But he was married to the another person, or still,
No, notice has to go.
lordship.
Who is 3? Who is 3?
3 is the driver, your lordship.
No relief has been sought for against the driver. Because since no relief has been sought for against the driver, no notice be issued to respondent number 3. First up, so far as respondent number 4 is concerned, requisites ordinary process and registered cover, requisites to be filed within 3 weeks for fresh service of notice.
My lord, in 20, I am appearing for respondent number 1 to 4, my lord, in 20.
It is wrongly listed.
Oh, wrongly. That obliged.
Serial number 22, MA number 425 or 15, Mr. Alok Lal for the appellant.
My lord, subject to your lordship's pleasure, my lord. In this case, this was an appeal against the order under 140. Now 166 has been decided, and in that case the liability has been fixed upon the owner.
So
then my prayer would be, my lord, this in view of this for subsequent circumstances deciding on the 166, this appeal will become infructuous, and I may be given a.
So 166, in 166, definitely this aspect has been covered that you have paid 140. And what about the recovery?
Well, the recovery part is to be given to me, my lord. Recovery part is to be given.
No. Recovery, if the liability is against the owner, the tribunal has definitely given you a right to recover the amount.
That is not there, my lord. That is not there.
In
That
166.
part is not there, but we have deposited 25,000 statutory amount.
I am asking you, what is the award in the 166? What is the judgment?
It 2,91,685
To be paid by?
to be paid by the owner.
So that means including this amount.
But that has not been bifurcated by the tribunal, unfortunately, Your Lordship.
That you decide then. And what are you submitting in this? Tell me.
But in this case, because in view of the subsequent decision of the another main application 166, this appeal, in my respectful submission, Your Lord, does not sustain. So therefore,
like you heard Mr. Alok Lal appearing on behalf of the
and the
appellant.
statutory amount which we have deposited may be refunded to us.
It admits that this appeal was filed against an order under section 140 of the Motor Vehicle Act, which is interim in nature. Next one. Next line. He submits that now the application under 166 of the MV Act of the claimants have already been decided
on 25th February 2019.
25th February 2019, and the liability has been fastened upon the owner of the vehicle. First up, he submits that in view of the subsequent developments, this appeal is rendered infructuous. First up. Next, considering his submission, this appeal is disposed of as infructuous. Full stop. The statutory deposited before this court by the appellant insurance company should be refunded to them.
And one more thing, my lord. The interim compensation, if paid, should also be recovered from the owner, Your Lordship.
That will be the final order.
Well, let this appeal can be disposed of, Your Lordship.
That is there in the 166 law.
Is it disposed of? To be considered disposed of appeal?
It's infructuous. Yes.
Serial number 23, MA number 187 of 16, Mr. Nityanand Prasad Chaudhary, for the appellant.
Earlier notice was issued, my lord. This is our issuance of succession certificate, my lord.
I'm appealing for OP number 3, Your Lordship.
Who is 2?
2 is my Malti to do.
So 2 is not appeared.
It appears, Your Lordship, that 2 is.
Fresh notice to respondent number 2. Registered ordinary both process requisites 3 weeks.
Serial number 24.
As for this case, by order dated 2011-19 notice.
Lordship, serial 33 perhaps, not 34.
24 हो रहा है, ma'am.
Oh, I heard 30. Tender apologies.
Lord, order dated 2011-19 notice issued by OP number 1, my lord. And I am noticing compliance by 27/11/19.
Fresh notice, both process, correct and present address.
Obliging.
Serial number 25, MN number 334 of 16, Mr. Vivashina for the appellant.
My lords, I am appearing for the appellant. My lords may see the order number 6, last order of 16th November 2021.
Yes.
Pursuant to this, my lords, I have filed IA number 7049 of 2021, bringing on record certified copy, because on earlier day, my lords, since it was Xerox copy, therefore my lord have said you bring on record certified copy of order.
Who is appearing?
I'm appearing, my lord, on behalf of claimant, my lord.
Yes.
But there is a relief shot against the owner, who is respondent number 7.
Where is respondent number 7? It's not appearing.
No one is appearing.
Treated valid. Notice upon respondent number 7 has already been treated to be validly served by order dated 11/9/2009. 11/9/2019. Full stop. Now, what about your IA? You are moving your IA.
Yes, my lords, I am pressing my IA because I am bringing on record the certified copy of the order passed in connection with the WC case. Now, my lords, may straight away come to page 23, my lords. What has happened in this case? Basically, I am not against the claim of the present claimants. My lords, the legal heirs of the driver of dumper have filed this MSCT case. He has parked the vehicle, and my lords, the another vehicle, which is the truck, which was insured with us, that came and dashed. Now, the owner has suppressed the fact during the course of entire proceeding that this driver of the truck, means the insured vehicle of ours, they have, their legal heirs have filed WC case before the Workmen Compensation Commissioner for grant of, because he has also died after dashing, for grant of compensation under the Employees Compensation Act. That case was dismissed, holding that he was underage and therefore he was not supposed to hold the valid and effective driving license. Relying on that judgment, I am praying before this honorable court that once a competent court has already held that the said person was not competent to hold the valid and effective driving license, there is a fundamental breach, and I should be given right to recovery.
So, what prevented you from bringing this document on record earlier?
My lords, two things, my lords. First of all, my lords, may straight away come to page 11, paragraph 11 and 12. We have given the evidence of one concerned investigator before the tribunal.
Is this case under the heading for admission along with the IA, which will be dealt with at that stage?
But it's claimants, if want, they can file their response to that, because on that day, if they will file.
In the meantime, the claimants are at liberty to file a response to this IA. Listed again.
Serial number 26, MN number 349 of 16, Mr. Kostora, Mr. Chandra Singh.
My lords, in this case, I am appearing on behalf of the appellant, my lords. What happens, my lords? There was an eviction suit. In the eviction suit, decree was passed in favor of the landlord. When the execution proceeding was going on, in the execution proceeding, miscellaneous case was filed by the third party that he is in possession of the land. And in view of that, he filed this title appeal number out of this execution case number 45 of 2009. And the learned court below, my lords, what in the last portion of the order sheet at page 24, gave a direction that in the result, keeping in view all the facts and circumstances and the material available on I am of the considered view, that there is a merit in the title appeal. Accordingly, this title appeal is allowed on contest, and the entire case record of title appeal 33 is remanded back to the trial court with the direction that appellant objector be given an opportunity in order to decide the right title interest in respect to the decretal property. With this observation, this title appeal is allowed. The order dated 23/2012 passed by the trial.
The title appeal be remanded. The suit.
My lord, I beg your pardon.
No, what was the miscase?
Miscase, my lord, for that third party filed the miscase to hear them on that they are in possession. Hardayal Singh was in possession. That is their case. That was dismissed. That miscellaneous case, and against that miscellaneous case, they filed this.
They filed the miscellaneous appeal.
This title appeal.
Why title appeal?
That is what I don't know, my lord. I can't say at the moment why title appeal. It must be miscellaneous appeal, my lord, at that time. But title appeal has been filed, and in the title appeal, my lord, miscellaneous case number 6 and rising of execution case was quashed, my lord, set aside. Accordingly, this appeal is disposed of. And
how can this the title appeal is allowed on contest, and the entire case record of the title appeal is remanded back to the trial court with the direction to the appellant objector the opportunity to decide the right title and interest in respect to the decreted property. So the suit was for?
And he is a third party, my lords. That is
the suit was for?
For eviction of the tenant, my lord. Tenant was Mr. Ganesh Prasad. He lost the suit. He was not even this. Hardayal Singh was not even a party to the suit. He filed the title appeal.
Where is the order of the miscellaneous case? Where is the judgment of the miscellaneous case?
My lord's miscellaneous case, my lords, subject to your lordships.
Bring it on record.
My lords, I will bring it on record.
What about the notices? Notices have not been served upon 1 and 2.
In that case, my lords, I will take fresh steps of notices. If not, sir.
Fresh steps to respondent number 1 and 2, ordinary and registered cover, requisites 3 weeks.
My lords, I am obliged. I am obliged.
Number 27, MA number 445 of 16. Mr. Shekhar Pratap Sinha, Mr. Bhayavi Shibir Kumar.
My lord, I am appearing on behalf of the appellant, my lord.
Yes.
This is appeal, my lord. Probate of will. Application for probate of will was rejected, my lord. On the ground, in paragraph.
Taken steps.
My lord.
You have not taken steps.
In this case, respondent have appeared, my lord.
Respondent number 2 has not appeared.
I just appear only on behalf of respondent 134.
Issue fresh notice upon respondent number 2, registered ordinary, requisites 3 weeks.
Obliged, my lord.
Serial number 28, MA number 446 of 16. Mr. Rajiv Lochan.
In this case, my lord, I have filed a petition for condonation of delay, IA number 11079, for condonation of delay in preferring. There is delay of, my lord, 9 days delay in preferring the instant appeal against the order, my lord, dated 19/5/16.
Notice served on respondent number 4.
Yes, my lord.
3 and 4, how? How the notice was served? Let us see. Fresh draft he wanted. Right? Fresh draft. Respondent number 3. Mr. Aloklal, which case? This is? No, this is a different case. Serial number 28.
In serial number 28, my lord, I am appearing, my lord.
You're appearing, yes.
I have filed a limitation petition, my lord, for condition of delay of 9 days, my lord, in preparing this appeal.
9 days. Who is appearing for the opposite party?
Notice has not been still issued.
Issued.
Notice has not been issued till date.
Issue notice on the limitation matter and the main matter upon the respondent numbers 1, 2,
13.
1, 2, 14. Ordinary process 4 weeks.
Serial number 29, MA number 454 of 16, Mr. Aloklal.
Lordship, in compliance of order dated 6/2/2020, I filed affidavit regarding paper publication.
Paper publication of respondent number
3 and 4.
It is only 3. Where is 4?
Respondent number 3 and 4, Lordship. Owner and driver of the.
There is only 3 paper publication. There is another petition that you want to again publish it in the newspaper. Go through it. Go through it. This is this case on the on a date when the court hears the cases physically.
Serial number 30, MA number 495 of 16.
My lords, at the outset, my lords, I'll submit in this case on 20th January, the order was given for paper publication, my lords, against respondent number 4 and 5. And from my record, my lords, on 27th January, I submitted the draft, my lords, for approval of the office, my lords. And thereafter, my lords, everything was, my lords, lost and it had not been done. I pray for fresh order with only. I
Office
apologize.
is directed, counsel for the appellant submits that the draft which was handed over to the appellant's counsel.
No, not handed over, my lords. We submitted before the order was to, we have to submit before the office. Then
Yes.
office was supposed to, my lords, send it back to us.
Yes.
But it could not be collected from the office, my lords.
Collected?
My lords, right now, my lords, I will have to, fresh order is required. I'll again file, my lords, I'll do everything again, my lords. Because it is now 2 years have elapsed, my lords. On 27 January 2020.
When did you hand over? When did you hand over?
On 27 January 2020, my lords. Order was for me to, my lords, file the draft notice before the office. And then,
Draft
my lords,
publication has been received. Copy of the draft publication has been received on 11/2/20. Then, when was it handed over to you?
that is not available in my record. Therefore, I was praying, my lords. Fresh direction is required. I apologize at the outset.
My lord, with permission, may I submit one thing, my lord?
Yes.
My lord, in this case, there are two insurance company, my lord. One has also filed a MA number 550/2017, my lord, which has been decided by in this coordinate bench, my lord, on 18/1/2020. Bajaj
Yes,
Allianz.
that can also be done because the issue is, my lords, if my lord will permit you, my lords. Issue is that there were 3 vehicles involved, but only 2 vehicles were made pleaded as party, my lord. That is fully covered by Kheni's judgment. Second issue is that why notice has been issued, my lords, because we have taken a plea that in the written statement it was mentioned that he be directed to file copy of permit and driving license, which was not done by him.
The counsel for the counsel for the appellant praised that he may be given an opportunity to file a draft for paper publication, a fresh draft for paper publication before this court. Full stop.
For 4 and 5.
Before this court, comma, for issuance of notice upon respondent number 4 and 5. Full stop, prayer allowed. Fresh draft should be submitted before the office within 3 weeks. Thereafter, the notice should be published and an affidavit should be filed before this court.
But I'm appearing for the caveator along with my friend. In the meantime, at least some the statutory amount may be released in favor of the claimants, my lord. The very poor people.
You file an IA. You file an IA. We'll see to it.
Serial number 31, MA number 551 of 16, Mr. Neeraj Kishore. For the appellant.
Lords, I am appearing for respondent. If your lordship sees the limitation petition has been filed after 3 years, Lords. After filing of the appeal, Lords, we have to file a rejoinder to this, Lords.
Once respondent wants to file a rejoinder to the application filed under Section 5 of the Limitation Act, they are allowed to discuss after 3 weeks.
Obliged.
Serial number 32, MA number 597 of 16, Mr. Alok.
Lordship, in this case, notices issued, but service report I am not aware, Lordship.
It has been reported that respondent number 1 is dead. Full stop. Counsel for the appellant prays for some time. Prayer allowed. Is this case after 3 weeks, 4 weeks?
Obliged, Lordship.
Serial number 33, MA number 604 of 16, Mr. Amit Kumar Das.
May I please, Your Lordship, in this IA for condonation of delay has been filed, IA number 7573 of 16, Your Lordship. And there is a delay of 645 days. And the reasons we have stated in paragraph 2, 3 and 4 of said IA. In paragraph 2, we have stated that the conducting lawyer...
have you filed the substitute service?
Yes, Your Lordship. And supplementary affidavit has also been filed.
The substituted service of notice upon respondent number 6 has been effected. Full stop. Affidavit to that effect has already been filed by the counsel, by the appellant. Full stop. Thus, the notice upon respondent number 6 is treated to be validly served. IA number?
IA number 7573 of 16, Your Lordship.
7573 of 16. Yes, what is the ground?
Ground, Your Lordship, it is in paragraph 2, paragraph 3 and 4, Your Lordship. In paragraph 2, we have annexed the medical documents of the conducting lawyer in the tribunal below, Your Lordship. He was unwell and hence we were not communicated the order of the tribunal, Your Lordship. And thereafter in paragraph 3, his letter by which he communicated to us, Your Lordship, even that has been annexed. And in that process...
Who is appearing?
My lord, I am appearing on behalf of respondent claimant, my lord.
Yes. What do you have to say?
My lord, since the conducting lawyer was seriously ill, it may be considered, but may kindly see the
Yes.
date of admission
Yes.
in the said hospital was 5/7/2015, whereas the award has been passed on 25/11/2014. So this is a company, my lord. So it is very strange how this can be happened.
because there's a delay of 627 days in filing this appeal.
645 days, my lord.
No, 627. The counsel for the appellant submit that the conducting lawyer who was conducting the trial before the tribunal was seriously ill and had to be admitted in hospital. Full stop. The documents of hospitalization and other medical documents have been attached with this IP. Full stop. Next paragraph. Counsel for the respondent opposes and submits that though admittedly the learned counsel was seriously ill and was admitted in hospital, but the admission had taken place, but he was admitted after the judgment was pronounced. So he submits that the appellants being a company should be more diligent. Full stop. Next paragraph. After hearing the counsel for the parties, I find that sufficient ground has been shown to condone the delay. Full stop. This delay is thereby condoned unless this case under the hearing for admission. Next week.
Obliged.
Serial number 34, MA number 619 of 16, Ms. Sunita Ojha, for the appellant.
I am appellant. I am appearing on behalf of the appellant, my lord. In this case, IA number 282/16 is pending before you, lordship.
16. Who has appeared? None has appeared.
Notice has also served on 10 December 18, my lord, by ordinary process.
Fresh notice by ordinary process upon the respondent.
Obliged.
Requisites 3 weeks.
Serial number 35, MA number 66016, Mr. J.M. Upadhyay, Mr. Navneet Sahai.
Yes.
My lord, I am appearing on behalf of respondent number 2, my lord, Just Insurance Company. In this case, my lord, right of recovery given to the insurance company.
Issue notice to respondent number 1, ordinary process, requisites 3 weeks. Yes. Yes, next.
Under the heading for admission, serial number 36 with serial number 37, MA number 145 of 15 with MA number 252 of 15. Mr. Arvind Kumar Lal for appellant first case, Mr. Alok Lal for appellant second case. Mr. Shahid Khan, Mr. Alok Lal, Mr. Rajullah Ansari, Mr. Suraj Prakash responded in first case. Mr. Arvind Kumar Lal, Mr. Shahid Khan, Mr. Suraj Prakash and Mohammad Sahuddin responded in second case.
In this case, my lord, my humble prayer is, my lord, since I am not feeling well and suffering from some headache, my lord, therefore kindly let the cases be taken next week, my lord.
No, next week लंबा time कर दीजिए, after 2 weeks कर दीजिए.
Yes, कर दिया जाए.
After 2 weeks.
I'm suffering some internal fevers, light fevers like that.
Let it be after 2 weeks.
Actual petition has not yet been filed.
Not 5 minutes.
Yes. Substitute not yet been found, Mr. Lal.
Lord.
So far in my appeal, it seems that one substitution petition is there.
Okay.
No, no.
Lal prays for some time on his health ground. We are allowed this case after 2 weeks.
On the ground is after 2 weeks. बोला था भाई
Serial number 38, serial number 39, MN number 314 of 50, with MN number 422 of 17, Mr. Anjali Kumar, Mr. Chandrajit Mukherjee, for appellant in first case, Mr. Alok Lal, for appellant in second case, Mr. Mohammad Asadul Haq, Mr. Amit Kumar Lal, for respondent in first case, Mr. NB Lal, Mr. Vishal Kumar, for respondent in second case.
Same prayer, my lord.
Adjourn.
I'm appearing for respondent number 4 in serial number 39. The counter affidavit is in the process of filing, my lord. I tender my apology.
Counter affidavit for what purpose? In an appeal, where is the scope of counter affidavit?
There is a necessity of counter affidavit in this case. My lord will recollect in this case, the PC number was found on the bumper.
Okay.
And the owner has appeared.
Okay. This case after 3 weeks on behalf of the on the request made by the parties.
Much obliged.
One thing, Your Lordship, in this case, there are several judgments of the Honorable Supreme Court on that issue. That Shafiq Ahmed case. Can I send those things on the Your Lordship's email? The recent judgment has also come.
No. And list this case full stop. Usko take down. List this case when the court starts hearing the matters physically. Physical. Yes, next.
Serial number 14, MN number 519 of 15, Mr. Manish Kumar for appellant.
My lord, in this case, on the last date on 8th February, my lords, notice was deemed to be validly served upon the owner of the vehicle, my lords.
Yes.
And the only issue involved in this case is, my lord, that despite giving a finding that the permit was not effective on the date of accident, the learned tribunal has saddled the company with the liability. My lord will come directly to page number 15, last line.
LCR is there?
No, LCR is not there.
Call for the lower court records, as it would be necessary to appreciate the argument of the counsel for the appellant, who takes the plea of invalidity of the permit.
Obliged.
Serial number 41 with serial number 42, serial number 43 with serial number 44, with serial number 45, 46 and 47. And number 494 of 50, Mr. Baso Chatterjee for appellant in first case. Serial number 42, MA 586 of 15, Mr. Baso Chatterjee for appellant in second case. Serial number 43, MA 587 of 50, with MA 591 of 15, with MA 592 of 50, with MA 593 of 50, with MA 595 of 50, Mr. Basu Chatterjee for appellant in all the cases, and Mr. Nikhil Ranjan for responding in all the cases.
Yes.
My lord, I am certain pages are not found, my lord, in my file. I was, my lord, kindly give 2 weeks time. And one particular case, 595 of 2015, it is also in the same. That has not been mentioned. That can also be taken, my lord.
Yes, serial number 47.
My lord, my lord.
Yes. You are not ready to argue this case today.
No, my lord. Certain papers are not available, my lord. It has been.
That this Some
2 weeks or 3 weeks, my lord.
certain papers are missing from his file. So he plays for some time. There's this case after 3 weeks when the court starts hearing cases on physical mode.
Lord, one thing
And my
owner
lord,
has not
595 of 2015, that may also be taken up, my lord.
You don't want to argue the case and you are saying that taken up. Now first decide what you want to do. Yes, Mr. Nikhil Ranjan.
My lord, owner is the necessary party and he is not appearing. Whether notices have been issued, that can be.
We'll see to it.
My lord,
the next day.
Obliged.
Serial number 48, MA number 234 of 16, Ms. Mangwa Pali for the appellate, Mr. Harendra Kumar Singh, Ms. Rekha Singh, and Mr. Dharmendra Kumar Mantiar for the respondents.
My lord, I am appearing in this case, my lord. The RC case has been dismissed on the ground of jurisdiction, my lord, and not considered the documents filed by the appellant, my lord.
Come
And
to the award. Come to the award.
my lord, that's page page 5, my lord. 6, my lord. Page 6 from the judgment award. My mayor
Yes.
read it whole, my lord.
Yes, read the entire judgment.
This claim has been filed for a grant of compensation under section 3(4) and the 23 of the Employees Compensation Act 2023. In short, the act on account of injury caused by the applicant Vijay Jadhav. Brief fact is that, my lord, Vijay Jadhav therein after called and the applicant injured was said to be an employee of OP1 Sanjay Kumar, thereafter called as the owner employer, working as a khalasi of owner's heavy vehicle truck bearing registration number such and such, dated on 4/6/2009. Injured was on duty. The said truck was running when the truck reached near Sukri Primary School, Tahsil Thana, Ituwa district such and such. Then said truck came into direct contact with live high tension electric wire and got fire. Consequently, driver and Khalasi both sustained several burn injuries. They shifted to district hospital Siddharth Nagar, UP. At the time of said accident, said vehicle was insured under the Office of Opposite Party number 2, United India Insurance Company Limited. Thereafter, they called the insurance company. It was alleged that after long treatment, applicant become 80% disabled due to said injuries. Hence, the instant claim case for compensation under the act was filed by injured applicant himself against the employer owner of the insurance company. Notice was issued. Employer and the insurance company appear and file their respective written statement. 2 witnesses have been examined on behalf of the applicant. No evidence has adduced by employer and the insurance company, but the witness of the applicant were cross-examined only by the insurance company. Heard argument on behalf of the applicant and insurance company, none appear of the employer. Pursue the record. Sri Singh, learned counsel for the applicant, submitted that applicant was on duty as a khalasi on 4/6/2009. The said truck met with an accident as aforesaid injury caused to the applicant due to said accident arising out of and in the course of employment thereafter. Therefore, applicant is entitled to get compensation as per provision of the act. At the time of accident, applicant age was about 22 years and getting monthly wages 4,000 per month. Learned Council has fairly admitted that accident took place in the state of UP, but emphasized that since the applicant and employer are presently residing at Dhanbad, therefore the court has territorial jurisdiction for trial of instant case. In support of this, Learned Council has relied upon such and such. Learned Council Sri J.K. Pradhan, though not disputed the insurance of the offence vehicle at the time of alleged accident, but passionately opposed the claim on the ground that document filed by the applicant, including medical prescription, disability certificate, bills, etc., has not properly been proved. certified copy of FIR charge sheet and report of first medical examination held just after the accident is not on record. That vehicular document, including a driver license of the applicant, has not been proved, nor have copies of said document have been furnished. Virtually no such accident took place. Secondly, UP State Electricity Board is necessary party in the prevailing fact and circumstances of the case, but said electricity board was not made party. Therefore, instant case is not maintainable at all. Secondly, by pointing out various contradiction, lacuna in the pleading and evidence adduced by the applicant, landed counsel has opposed the claim on the ground of territorial jurisdiction also. It was pointed out that accident took place in the district Siddharth Nagar, UP. Applicant is actually resident of district Aurangabad, but for the purpose of manipulation of judicial process, it was mentioned that he is resident of district Dhanbad. Nothing but on record to strengthen the fact that employer has its registered office at Dhanbad. Surprisingly, employer has adduced his written statement and thereafter not appeared nor has taken any step in the instant case. Applicant has failed to prove his employment, wages, and age at the time of accident. Therefore, the instant case is not maintainable by all corner and therefore liable to be dismissed.
Please
To
compensation.
his, my lord,
Yes, yes. You continue.
argument landed council relied upon state of Jammu and Kashmir versus Jarda Begum, reported in 2004, volume 1, TAC 493, Jammu and Kashmir. And issue frame, my lord. Thus, after considering the pleading, evidence, and argument advanced by the parties, following issues are under consideration before this court. Whether instant case is maintainable in its present form. Second, whether applicant got injury due to alleged accident arising out of and in the course of employment. Whether this court has jurisdiction for trial of instant claim case. Finding, my lord. Issue number 1 and 2. Two witnesses have been examined on behalf of the applicant. A1 is Vijay Jadhav, applicant himself. He deposed that as per direction of the employer, he along with driver, after loading coal in the said truck, went Siddharth Nagar after unloading the coal at brick kiln Ita Bhatta. They were coming back by said truck. At Sukri Primary School, the said truck directly contacted with 11,000 volt electric wire. Fire took place. Applicant and driver along with truck have been badly burned. He has proved the disability certificate AW1. He has also identified Xerox copy of some document marked by X series. Secondly, witnesses is father of the applicant, namely Naresh Yadav, AW2. He deposed that he went to the place of occurrence and saw that truck was badly burned. Villagers informed him that driver and cleaner have been hospitalized. He was referred for A.N. Magad Medical College Gaya, where he was under treatment for 1 year. He is still under treatment. This witness has also proved some document. Before considering the pleading, it would be appropriate to quote here some case law cited by the parties in New Indian Insurance Company versus Kanangabati 2003, volume 1, JLZ 103. Victim sustained injury by motor accident to the extent of 68% permanent disable caused him by those injuries. The tribunal has awarded sum of rupees 4,86,000 as compensation in favor of the claimant. It was observed by Honorable Jharkhand High Court in Para 2 that undoubtedly the course of action adopted by the claimant was not legally correct, is as much as the tribunal should not have exhibited the aforesaid documents because these documents were not properly proved by the claimant. The only way by which these documents could have been proved and hence admitted into evidence was by producing the author of the documents who could prove the certain of the documents, identifies his signature, and on and so on and so forth. If a claimant during the course of his evidence appearing as his own witness is allowed to produce any number of documents and also get them exhibited without the authors of documents.
What is wrong in this judgment?
Not consider his documents he has filed before the honorable tribunal, my lord.
There are series of documents which says that the documents has to be properly proved. None of the documents were proved. Your certificate, disability certificate, was also not proved by the author of the certificate. None of the doctors were produced.
He ordinarily, at that time, he ordinarily lived at Aurangabad, my lord, but his permanent address is at Dhanbad.
No. Jurisdiction is jurisdiction. Where it has not been decided only on the ground of jurisdiction. The case was not rejected on the grounds of jurisdiction.
Not producing any documents and jurisdiction, both, my lord.
Even if the jurisdiction issue is set aside, where is the jurisdiction?
One judgment, my lord. Section 21(1) of the Employees Compensation Act, my lord, reported in 2007, Volume 4, Jail Jar, Supreme Court 195. My lord, the claimant can apply before the commissioner having jurisdiction over the area where the claimant ordinarily resides, and it is not always reside.
So what are the documents to show that he ordinarily resided in Dhanbad? No, not a single document.
At that time, he not produced, my lord. But
how can the court infer? How can the court
maybe permitted to file a supplementary affidavit, my lord?
Why?
To annexing the all documents, my lord. He resided at Dhanbad at that time.
This is an appeal, madam. This is not a writ application. The evidence is a supplementary affidavit.
Is also, my lord, when documents have not been filed before the court below, then, my lord, I need to file, my lord, before the honorable court.
Where is the scope?
Kindly consider that judgment, my lord.
Which judgment?
He is always necessary to prefer a claim petitioner where the accident has been taken place. This is for facilities of the workman and advance the cause of welfare of the workman, my lord.
Yes, the court says that you have not produced any documents to show that you ordinarily reside within the district of Dhanbad.
Dhanbad, my lord.
Clearly in your cost
record may be called for, my lord.
Call for the lower court records.
Serial number 49, MN number 439 of 16, Mr. DC Jha.
Lordship, in this case, there is a serious dispute with regard to identification of the vehicle, Your Lordship. And in this regard, Your Lordship, we have examined our branch manager, and the policy was issued in favor of the Maruti Alto car, but it has been used in a commander jeep, Your Lordship. Identification of the vehicle has been used. Let us see where is the issue. Yeah, I am coming, Your Lordship. But the owner has not yet appeared in this case, Your Lordship, because yes, I am coming. Page 4, internal page 4, para 8 and 9 may kindly be seen. Para 8, Your Lordship. Para 8? Yes, Lordship. Of the judgment? Of the judgment, Your Lordship. Page 4. Yes. The opposite party number 1, who is the owner of the vehicle, did not lead any evidence or submitted any document in support of his case. And now, para 9, Your Lordship. The OP number 2 examined 1 Yugal Kishore Vanwal, branch manager, OPW 2/1,
and relied upon the carbon copy of the certificate of insurance cover note, which has been marked as Exhibit A. Up. Now please come to your lordship, issue number 4. That is on page number 9, page number 8, your lordship. Issue number 4. Whether the offending vehicle UP in 84A 84A6067 was validly insured with the Oriental Insurance Company OP number 2 on the date of accident. The claimant has relied upon the carbon copy of the claimant, your lordship, not the owner, has relied upon the carbon copy of the certificate of insurance which has been marked as.
I seriously object, my lords. There is no such word like carbon. The word is only copy of the certificate.
So should I complete, your lordship?
Yes.
Mark as Exhibit A. To disprove the same, OP number 2 examined the branch manager OPW 2/1. His testimony reveals that an insurance policy was issued to the owner Maruti Alto bearing number such and such, but is marked X/3. Certificate of insurance filed by the claimant. No, I am coming. Maruti Alto has been substituted by the word Mahindra Commander. According to him, the said Maruti Alto car did not met with an accident and its number was being used by the owner in Mahindra Commander Jeep. Now, objection of my learned friend, the carbon copy of the certificate of insurance of Maruti Alto car was marked Exhibit A at the outset. Thereafter, your lordship, by his own reasoning, the learned MSCT has said no, Exhibit 1 is not correct. X/3, which has been filed by the claimants, are the genuine documents. And by this way, this document and the evidence has been rejected.
Call for the lower court records to appreciate the argument. Call for the lower court record.
Lordship, the owner notices were issued to the owner also, but he didn't appear here, Lordship.
Issue notice to the owner of the vehicle by ordinary process requisits 3 weeks.
And I am appearing for the respondent claimant 1.
You are for the claimant?
Yes, my lords.
Serial number 50 with serial number 51, MA number 460 of 16 with MA number 533 of 16. Mr. Arvind Kumar Lal for the appellant in first case, Mr. Alok Lal for appellant in second case, Ms. Amrita Kumari, Ms. Rakina, Ms. Priya Agarwal, Mr. Alok Lal for respondent in first case, Ms. Amrita Kumari, Ms. Priya Agarwal, Mr. Arvind Kumar Lal for respondent in second case.
My prayer for adjournment, my lord.
Mr. Alok Lal prays for
Arvind
Kumar Lal prays for some time on.
Let it come after Holi, your lordship.
Health ground. We are allowed in this case after 2 weeks for sub case to be listed when the court hears cases in physical mode.
My
Serial number 52, MA number 503 of 16, Mr. Shyam Narsalia, Mr. Ajito Sen, Mr. Akash Bhushan for the appellant, Mr. Rajesh Kumar Mahata, Mr. Ajit Kumar Sinha, Mr. Manish Kumar, Mr. Amit Mishra for the respondents.
Lordship, in this case, I am appearing on behalf of the appellant. Lordship, I seek only one adjournment, Lordship. The file was with some earlier conducting advocate. Just I am praying for only one adjournment, Lordship.
On the request made by the appellant, this case is adjourned for a week.
टाइम मिलेगा तो बोलना तो हम
Lordship, my presence may be marked, your lordship.
Give your slip, appearance slip.
As lordship.
Under the heading for hearing, serial number 53, MA number 202 of 15, Mr. Alok Lal for the appellant, Mr. Vinod Kumar Singh, Mr. Gaurav, Mr. Rajendra Ravidas for the respondent.
But in this case, only the issue of quantum is there. Nothing else.
Mhm.
Future prospect has been added as 50%. Conventional head 2,25,000. Monthly income has been taken to be rupees 5,000.
What is wrong?
But this is an accident which has taken place in the year 2012.
Yes. 2012 monthly income 5,000. What's wrong?
Then it's all right, Lordship. But so far the other aspects are concerned, Your Lordship. 50% is the future prospect, and conventional had 2,25,000.
Yes, who appears for the respondents?
And the interest is also at the rate of 9%.
Interest. Who is appearing for the respondent? देखिए, just Vinod Kumar Singh, R.R. Ravidas, D.K. Jaiswal.
The penal interest has also been imposed at the rate of 12%. And in pursuant to Lordship's direction, we have deposited rupees 6 lakhs.
Where is the counsel appearing on behalf of the claimant?
They have entered their appearance, and then the notices, the
Yes.
delay was.
Yes. Who is appearing?
There are several set of counsels appearing.
Take down Mr. Alok Lal argues the appeal. LCR hai? Appeal.
LCR was called for, yes, Lordship. On 29/8/2018, the LCR was called for.
The challenge to the award is the quantum, is the assessment of the quantum. Mr. Alok Lal submits that future prospect. He submits that the amount of compensation has been enhanced by 50% on the ground of awarding on the ground of awarding compensation on account of future prospect. He submits that in the case of Pranay Shetty, so and so, how much it would be? What was the disease as? Disease was an employee.
Could not calculate it because
Disease was the employee of?
he was not the employee. He was the labor 37. He was not the permanent employee.
He submits that the deceased being not a permanent employee,
37 years,
and aged about 37 years, 40% enhancement should have been awarded. First up, he further submits that on the conventional ahead also a huge amount has been awarded, which is not in consonance with the judgment of the Honorable Supreme Court in the case of Pranay.
He was 40 years old.
Next part. None appears on behalf of the claimant when the case is called out, though they are being represented by a set of counsel. To give one more opportunity to the claimant, let this case when the court starts functioning in physical mode.
क्या करेगा आदमी बोलो ना दो इसको दो
Serial number 54, MA number 185 of 16, Mr. Alok Lal for the appellant, Mr. Santosh Kumar Chaudhary, Mr. Mahesh Kumar Mahato, Mr. Ashutosh Anand for the respondents.
Yes. Who is appearing? Yes, Mr. Lal. Mr. Alok Lal, you are appearing. Unmute yourself.
Sorry, I'm appearing for the appellant, but in this case, we have challenged the liability on the two counts. Firstly, on the point of no driving license and the permit. Now, kindly see paragraph 7 and 8 of the award.
Yes.
7, second paragraph, subparagraph.
Yes.
However, one witness, namely Shiva Batra Ghosh, an investigation has been appointed to examine who has proved the verification report dated. Well, perhaps they are asking for time. I don't think that it will be proper for me to argue in part.
Who is asking for time? No one is asking for time.
That Ms. Rishi Bharti is there, perhaps Ashutosh Anand is there. Whether she'll argue or not, I do not know.
Your Lordship, in this case, I am filing Wakalatnama, Your Lordship. 1 week may be granted, Your Lordship.
Wakalatnama on behalf of the owner?
Respondent number 6, Your Lordship.
Who is respondent number 6?
Owner, Your Lordship.
The owner of the vehicle, Ms. Rishi Bharti, submits that she is filing Wakalatnama today on behalf of the owner of the vehicle, who is a necessary party to this litigation. Full stop. Considering his submission, is this case after 1 week?
Because the other cases I have not gone through, a lot of mine. Frankly, submitting, I have not gone through those cases, other cases.
Then let the matter be called out.
Serial number 55, MN number 305 of 16, Mr. D.C. Ghosh, Mr. Nilesh Kumar, Mr. Avneet Kumar Sinha, Mr. Arvind Kumar, Ms. Amrita Srivastava, Mr. Vijay Prasad, for the respondents.
Yes, Mr. Ghosh.
Your Lordship, I'm appearing on the behalf of the opposite party.
Yes.
I'm appearing on behalf of respondent number 3 and 4, my owner and driver, man.
Okay. Yes, Mr. Ghosh. Unmute.
My lord, on my personal ground, my lord, this may be taken on any other day. Today, I am not feeling well. I can understand in so many cases the time adjournment has been granted, my lord.
On the request of Mr. D.C. Ghosh on personal health, this case is adjourned for 2 weeks. Yes, next.
Serial number 56, MN number 308 of 16, Mr. Vijay Kumar Sharma, Mr. Alok Lal, Vijay Kumar Sharma, Mr. Vijay Kumar Sharma for appellant, Mr. Alok Lal for the respondent.
But perhaps in this case, this file has been assigned to Mr. Manish Kumar as I could recollect.
His name is also there.
Yes, he is because copy was served upon me and he is signed the file.
Yes. Who is appearing? Later. Just see the Wakalatama. Who is appearing for the insurance company? Yes, Mr. Manish Kumar, where are you? Mr. Manish Kumar. Yes, what is this appeal? This appeal is for enhancement. Who is appearing for the appellant? No one appears on repeated call on behalf of the appellant. This case is adjourned for 3 weeks to be listed at a physical hearing date. When the court resumes hearing in physical mode. Next.
Serial number 57 and number 422 of 16, Mr. Alok Lal for the appellant, Mr. Shekhar Prasad Sinha, Mr. Anil Kumar for the
Yes.
In this, I'll do it. I'll do it. Well, it would not be proper for me to ask your lordship to rise before such time. So I'll be doing it. I'll be reading, and then I'll try to assist your lordship.
Where is Mr. Shekhar Sinha?
I'll try to assist your lordship.
Where is Shekhar Sinha?
Cases should be finished, your lordship, because otherwise it will again be troublesome for me to read and go through it again. May I submit, your lordship?
The award has already been satisfied.
Yes, award has been satisfied in this case.
Where is Mr. Kumar appearing on behalf of the owner? Anil Kumar?
Lordship, I am appearing for respondent number 2, my lord.
Okay, owner. You just tilt your camera upwards. Just tilt your camera upwards. Yes. Yes.
Lordship.
Let us. Yes.
I'm concise my submission only
Right
on
to recovery. Right to recover.
Yes, some of the paragraphs.
Yes.
Issue number 4 and 5 decided at paragraph 14. The tribunal has categorically found the adverse inference due to non-production of the driving license and all those things. But surprisingly enough, in paragraph 28,
LCR, yes.
LCR is there.
Yes.
Simply in paragraph 28, the learned tribunal has come to a finding that since the vehicle was insured, therefore the liability is due upon the insurance company without giving any right of recovery.
What is your pleadings?
Now, my pleading is kindly come to paragraph. That is apparent from the judgment itself.
No. Let us come to the pleadings. Don't go to the judgment.
Yes.
Well, when the pleading is with me, why should I go to the judgments?
Well, I'll try to assist your order because yesterday I could not go through it, but since in this case there was a petition filed by us in the form of interrogatories that is on record. A petition summoning the defendant number 1, Jaikant Kaur, wife of Dayal Singh, resident of such and such. And in this case, we have asked them to produce those documents that was filed on 20th of May 2015. That petition is there. That was for summoning the owner to produce those documents under section 169(2), which is one of the requirement of the provisions of the Motor Vehicle Act. Now, in this case, as it would transpire from
What is the judgment? What is the judgment you will be relying upon?
Pappu versus Vinod Kumar Lamba.
Give the reference Pappu versus Vinod Kumar Lamba.
I'll give the Pappu versus Vinod Kumar Lamba and Amrit Paul Singh versus Tata IIG. Now, my submission would be.
Give the reference.
Well, I'll give the reference. Just now, I'll give the reference.
Yes.
I'll give the reference. Well, in fact, it is saved on my desktop, so I can. Pappu versus Vinod Kumar Lamba is.
Yes.
2018 Volume 3 SCC.
2018 Volume 3 SCC.
208.
And Amrit Paul Singh.
And Amrit Paul Singh is also 2018 Volume 7 SCC 558.
2018 Volume 7 SCC 558. It says the initial burden is upon the owner of the vehicle.
Owner of the vehicle. to discharge.
To discharge.
And if the owner fails to do so,
Yes, yes, owner who is appearing. What is your submission, Mr. Anil Kumar?
Lordship, may kindly be see para 28 below.
Yes,
Of
28.
running page 8 below.
Yes.
May I read below?
Yes.
As per exhibit 12, exhibit 12, insurance policy of National Insurance Company Limited, the offending vehicle was insured with defendant number 2 at the relevant time. Defendant number 2 in para 4 of its WS has also admitted this fact. In this way, it is clear that offending vehicle was insured with defendant number 2 at the relevant time and being insured of defendant number 1, and defendant number 2 is liable to indemnity the liabilities of defendant number 1. And my lord, in Motor Vehicle Act, my lord, 14, it says in clause B, my lord, if the person obtaining the license either originally or on renewal thereof has not attained the age of 15 years on the date of issue, or as the case may be, renewal thereof. A. Be effective for a period of 20 years from the date of such issue or renewal. Lord.
No, you are
B,
not putting the license
my
also.
lord, until the date of which person attained the age of 50 years.
Did you produce the license?
Lordship, after producing all the facts has been considered in the learned court below. Lord.
How do you explain para 24, para 14?
20.
Para 14, 1-4.
इसमें हुजूर हम ये कह रहे हैं कि ये जो कह रहे हैं कि इनवैलिड है लाइसेंस, तो इसके लिए हुजूर मोटर व्हीकल एक्ट में ये हम जो पढ़े 14 मिलो करेंसी ऑफ लाइसेंस टू ड्राइवर मोटर व्हीकल मिलो, इसी में क्लॉज बी में हुजूर हम पढ़े कि 20 इयर्स तक वैलिड रहेगा या 55 इयर्स तक एज तक मोटर व्हीकल एक्ट में है.
Did you have a license? Did the driver have a license? License was produced. Then the question of validity will come.
Lordship, after producing the license, all the fact has been considered in the learned court below.
License is exhibit. License was marked as exhibit.
Lordship, record lower court के record में हुजूर होगा, मेरे पास तो अभी पूरा record का नहीं है हुजूर.
Only then the learned tribunal has come to a finding that it has already produced an adverse inference has been drawn.
Did you appear before the tribunal, Mr. Counsel? Did the owner appear before the tribunal? The owner has appeared or not?
And they have not challenged this finding also. This finding is wrong. Kindly see paragraph 3.
Did the owner appear?
No, paragraph 3 may kindly be seen. That would speak in itself.
Read that.
After issuance of notice and publication in local newspaper, defendant number 1 did not appear in the court and case proceeded ex parte against him. While order dated 16/4/2013, defendant number 2 appeared and filed written statement.
The license is not on record, Mr. Counsel. The license is not on record. Yes, Mr. Anil Kumar.
Lordship.
The license is not also on record. Whether it was given by a person having a license or not, that is also now doubtful. And the court has drawn inference against you. When the court draws adverse inference against you, the court should proceed accordingly.
Without license, my lord, the motor vehicle, how can it be released, my lord? तो दे दिया हुआ होगा उस तो अब तो देखे मेरे पास नहीं है रिकॉर्ड.
We don't know.
It was not a case of motorcycle, it is a case of truck. Not a case of motorcycle release. He was on the motorcycle which was
You have
damaged.
already argued. Mr. Lal, you have already argued, not side by side. Let him argue.
Yes, yes.
If he is finished, he will say that he is finished.
लॉर्डशिप इसमें तो हम इंक्वायरी कर लेते हैं हुजूर, इसमें टाइम दे दिया जाए कांटेक्ट करके.
No. Unnecessary after the hearing is concluded, you will ask for time. Unnecessary lingering the cases. I don't think so from your argument that you have anything more to submit. Judgment reserved. Third judgment reserved.
All right.
Mr. Shekhar Sinha, you are appearing in this case? The award has been satisfied? Thank you.
I was not ready in this case. I was ready from my notes, which I prepared long time back.
Thank you.